Hello. Today I'd like to talk to you a little bit about some rules of interpretation and some other rules about remedies for contracts. So let's get started here. First thing I want you to notice is that some businesses use printed form contracts and then they type or handwrite additional items in those contracts. If that happens, courts will look at the handwritten terms and they will be in priority if they are different from the typed terms. The handwritten terms are the ones the courts will accept. If there are typed terms in the form, then those will control the printed ones. There's also a rule called the parole evidence rule that basically prohibits testimony about oral negotiations before the written contract. So, for example, if you and I are discussing you purchasing my house, and while we're talking I say, if you buy my house, I will also throw in my refrigerator and my furniture, which are not technically part of the real property, but I'll throw those in for free. And you say, that sounds great. And further, I say, I will also warranty the roof for 2 years. And you say, excellent. So then we write up a contract for you to purchase my real estate. But in that contract, we do not refer to or mention our oral agreements or the things that I promised ahead of time, like a warranty on the roof that I would give or throwing in the refrigerator, those types of things. Mentioned nowhere in the written contract. Well, in that case, the written contract is going to win out. So if I then break those oral promises that I made that were not included in the written contract, that's going to be too bad. You won't be able to take me to court and enforce those oral promises that were made before the written contract and are not included in that writing. So be very careful when you're doing a written contract that you have everything included there. So, applies to evidence of oral agreements made at the time of or prior to the written contract. Now, there is an exception. There can be testimony in court giving evidence of oral agreement that explains the meaning of the written terms. So, if there's some kind of special understanding about a written term and maybe it's ambiguous or we're not sure what it means, you can have oral testimony explaining the meaning of the term as long as you're not actually changing the term. Also keep in mind that if you are the party that was in charge of writing the contract, maybe your attorney wrote the contract, and the other party is the party who mainly just reads it and signs it, then any ambiguities in that contract are going to be construed against you, the party who wrote the contract. So that's another rule of construction with contracts. The ideal thing to happen is that you have contracts that are so good that you don't end up in court very often. And that's one valuable thing about a good lawyer who can write a good contract is if it's clear, not ambiguous, if there's not a lot of stuff left out or details missing, and the contract is very definite, you're going to have a better chance of staying out of court, which then saves you attorney's fees. So it's definitely worth hiring an attorney on the front end to write a good contract, because that may save you lots of legal fees later when you have to spend hours in court, which is much more stressful and bad for your business. Now, there can be excuses for non-performance of a contract. Now, if you do refuse to perform a promise, you can be sued for breaching that contract. But sometimes there are legitimate excuses for not performing. One example is impossibility of performance. That would excuse somebody from performing. So, now this doesn't mean that you say, oh, I can't perform because this is not practical for me. My profits are not going to be as high as I thought from this contract. That's not impossibility. Impossibility would be something like if the subject matter of the contract is destroyed. So if I agree to sell you my house and I agree to do that within a month and give you possession of the house, and in the meantime the whole house is destroyed by fire or earthquake or whatever, then it becomes impossible for me to perform. Now, it does have to be an objective test, and it has to be something that would apply to any party in any circumstance. There's something called commercial impracticability, which might, in some cases, permit a party of a sale of goods contract to be discharged or excused from performance and not be liable for that. If there is, for example, a manufacturer who wants to perform, but unfortunately a major source of the raw materials is unexpectedly interrupted, that might be a case of commercial impracticability, which would allow the manufacturer to get out of the contract because they're unable to get this major source of materials they need to make the product you are trying to buy. Now, this depends on the circumstances of the situation. It's a case-by-case decision there. Now, another thing that you can have that will mean that a contract doesn't have to be performed is a waiver or release. So maybe we agree that I'm going to purchase your house and you agree you're going to sell me your house. But for some reason, I can't perform. And you maybe don't care. Maybe you've already got another buyer. Maybe you don't care for some other reason. Maybe you understand why I can't perform. Maybe I just lost my job by surprise. And you might just decide, hey, it's not worth fighting this. I'm going to just intentionally relinquish my right to enforce the contract against you. If I fail to perform as a buyer, you can intentionally relinquish the right to enforce a contract. A common case I saw in real estate was if a real estate broker actually accomplishes finding a buyer for your house. In many cases, that means at that point, the seller owes the real estate broker a commission even before the buyer actually pays the money and actually closes the deal. However, sometimes things fall through. Buyers lose their job, can't get financing, buyers try to back out, and sometimes real estate brokers, as a matter of good business and good relations with their customer or their client, will waive their right to get a commission, even though technically, under the law, they may have already earned it when they found the buyer. So sometimes you can have that. A release is quite similar. It happens when a party declares that the other party does not have to perform when promised. And so the first one, the waiver, happens, though, after a contracting party fails to perform. And the release occurs before the contracting party fails to perform. So the release would be, I'm going to release you before it's even time for you to perform. A waiver would be, after you've defaulted, I go ahead and waive my rights to sue you for that. Now, breach of contract. This happens when a party does not accomplish or complete the obligation of performance, and there are remedies for that. The common way is money. So if you happen to fail to perform your contract with me, a lot of times I'll just sue you for money damages. Now, I do have a duty of mitigation. Mitigation is my responsibility as a non-breaching party. It requires me to take reasonable steps to reduce the damages. A great example might be if I rent you an apartment and you pay rent for a few months and then the lease is still there, but you just decide to quit paying rent and move out. Well, you still technically owe me the rent under this lease contract. However, as landlord, if I know I can get another tenant in there, I have a duty to mitigate my damages and get that tenant in there to reduce the amount of rent that you're going to owe to me under the rest of the lease. Now, there are some types of damages that I do want to mention. One is compensatory, another is consequential, and then there's also liquidated damages. There are other remedies as well, including equitable remedies such as specific performance, injunction, and rescission. Now, let's talk about these remedies a little bit further. First of all, there's compensatory damages, all right? And that's one of the more common things. It's court-awarded damages to put the plaintiff in the same position as if the contract had been performed. So it includes lost profits on the contract and the cost of getting a substitute performance. So sometimes that will be sufficient. Do keep in mind, though, that sometimes damages are not going to do the job. So there may be things like equitable relief, such as specific performance. Example would be in the purchase of land. There may be only one farm. Well, there is only one farm in the location of the farm you want to buy. It's unique. It's one of a kind. It's the only one in that location in the whole world. And so if the subject matter of the contract is unique, like a piece of land or a house or a rare piece of art, then money damages may not do you a lot of good if you are a plaintiff who wanted to buy the property and then was denied that right. So you may be able to compel or force the seller to perform their promised act of selling you this piece of art or piece of land. Because money damages are not going to do you a lot of good. You want the property. All right, back to other damages. Let me go back over here for a minute. Consequential damages is another type, and that's court-awarded damages that comes from unusual losses that are foreseeable. The parties knew these things would result from the breach of contract. So, you might have compensatory damages, which would be, for example, if someone fails to deliver a freezer that they're supposed to supply to your restaurant right before Saturday night business comes in, or a couple days before that, when you really need this freezer to stock up on supplies for your restaurant. They fail to do it. Well, if there's a cost of getting a substitute freezer, maybe you have to buy one that's slightly more expensive to stay in business that week, that would be compensatory damages. But you might also have consequential damages. If the supplier of the freezer knows that you're going to have to shut down your business for a couple of days if you don't get a freezer, and that actually happens and you lose business because of this, and it's damages that were foreseeable, unusual damages, then you might be able to recover not only compensatory damages, but you might be able to get some consequential damages out of the supplier. Or maybe, you're planning to sell televisions on Black Friday right after Thanksgiving. Your supplier fails to deliver. Well, there could be compensatory damages. If you have to buy higher priced TVs, you've lost profits because your supplier of the lower priced ones doesn't perform, but also you may have consequential damages. If this costs you, if it's foreseeable that this will cost you customers and on Black Friday, then there may be extra special damages if that was foreseeable by your supplier. Liquidated damages is the third type. Now, courts do not want to penalize. They don't want penalties, but they do want to compensate for losses. So sometimes breach of contract damages are kind of uncertain, and you may want to put in your contract something that estimates what those will be. A common example is when you hire someone to build a commercial building for you. So maybe you hire someone to build an office building for you, and you need that office to be open. You've got some things you want to get done and you want to get moved in. Or maybe it's a store building and you want to open by November 1st so you can get business throughout the Christmas holidays, that kind of thing. And so you decide that you want to put in your contract with this builder that they will pay you liquidated damages of maybe $1,000 per day that if they're late on finishing the building. So you might say the deadline for finishing the building is November 1st. If it's not finished by then the builder will pay me $1,000 per day until it is finished. As long as it's not an unreasonable penalty type amount, courts will generally enforce these because they're kind of an estimate of what the damages are. It's really hard to measure, what is it the damage if you're 1 week late finishing this building. Now, the builder, on the other hand, may want to negotiate a little bit and put in the contract something about reasons, such as weather that are out of the builder's control that might excuse late performance and not get the liquidated damages provision started. All right. Now, remember, if damages are not adequate, then you're going to want equitable relief, such as rescission, specific performance, and injunction. Now, I've already mentioned specific performance for unique items such as land or artwork. Rescission is another one. It requires each party to return the consideration given to each other. Things like fraud cases. Suppose that I sell you my house, and in the contract I even put in there that I guarantee that the foundation of the house is perfectly sound. When reality, I know that the foundation needs $50,000 worth of repair, and even then it may be faulty. Well, if you buy the house and then you discover this, you may not want to even stay in that house. You may just want, not damages, but you may actually want to just get out of the contract, and that's rescission. Injunction would be court order for a party to do something or refrain from doing something. That's often used for things like a license or intellectual property issue. So if someone steals your intellectual property, starts using your trademark in business, damages may not be the only thing you want. You may want this to stop, and so you may ask the court for an injunction, which is an equitable remedy. All right, I do want to give you a practical perspective on contract. Remember that understanding contracts is the key to conducting business. And if you can interpret contract law, you will be a more effective negotiator in business, which is extremely important. And you can create contracts that enhance the business activities. Some suggestions. Make your contracts in writing whenever possible. We already know that not all contracts must be in writing, but when possible, it's a great idea. It reduces the possibility of he said, she said types of lawsuits. Use plain English in your contracts. In the contract, tell the story of the relationship of the parties and provide a timeline with definite times for obligations to be performed. Avoid legalese. You don't have to use big complicated words, but you can just use plain English. There should be a flow from section to section. There should be clear definitions if necessary. You should proofread carefully. That's a big one there. If you make a mistake on the price and you may say you put $900,000 and you meant to put $990,000, sounds like a little typo, right? But there goes $90,000 if you make that type of mistake. So proofreading is huge. Read it over and over again. If there's something in a contract that you're asked to sign and you don't understand it, ask questions and talk to a lawyer. And consistently redraft to update. So if you change the price in one place and it's repeated throughout the contract, you need to change it everywhere so there's no ambiguity there. Thank you very much, and I'll see you soon.